court. Your Lordship, I will endeavor to finish by 12 or 1 as discussed. Good morning, Mr. Kayangela. How are you?
Good, how are you?
I'm good. Mr. Kayangela, today we will wrap up the cross-examination and, in essence, focus on the Fishrot matter.
Okay.
Now, during your evidence-in-chief, you testified that the investigation in respect of the Fishrot matter was premised on the appointment of Mr. Mike Ikipunya, Mr. James Hatukilipi as the chairman of Fishrot, and as well as in respect of governmental objectives and amendments to the Act. You recall?
Yes, I recall, yes.
Now, I want us to initially start off, or firstly start off with the appointment of Mr. James. Now, I'm not going to repeat what you have testified on, but I just briefly want to put Mr. Esau's version to you to allow you an opportunity to respond. Now, Mr. Esau testified that the former permanent secretary, Ms. Ivelwa, and himself, they had discussions regarding identifying people for the board of Fishrot as the previous member's term were coming to an end, or came to an end. He further testified that the late PS and himself assigned duty to each other, or they assigned duties to look for possible candidates for consideration to serve on the board of Fishrot, and that they consulted various individuals. Mr. Esau further testified that Mr. Esau asked that he asked Dr. Albert Kawana, the former AG, and he also recommended the name of a certain Sirka Usiku to be a member of the board and to be appointed. Mr. Esau further testified that he spoke to Mr. Shangala as he wanted to bring in a youth component, and that is how Mr. Shangala came to recommend Mr. James Hatukilipi. And one of the other names that was also brought to his attention, but not through Mr. Shangala, was a certain Vivian Groenewald, and also with discussions with the PS was his PA, and obviously the PS to also serve on the board. And after they then received the CVs, the PS was responsible to do the vetting of the respective parties that have been identified. Do you have any comment on that thus far?
I only having a comment that, yes, I know Ms. Sirka Usiku was one of the board of directors.
Mm-hmm.
And the second comment is that, as per the recommendation of Mr. Shangala, as you just indicated, he gave a specific reason as to why James has to be appointed. And I don't know whether that was a request from everybody who was tasked to identify the people. Mm-hmm. He recommended him to control Anna Erastus. That was the reason for him.
Mm-hmm. And did you obtain a statement from Anna Erastus to clarify that aspect?
We obtained a statement, but she did not clarify that.
Okay. Now, Mr. Esau obviously thought it was an earnest message from Mr. Shangala recommending Mr. James Hatukilipi. And in that particular message, or all of the discussions that they have, nothing revolved around setting up of a scheme in respect of Nemgomar. Even that message only refers to, I recommend Mr. James Hatukilipi.
Yes, but with the reason,
yes,
as I have just stated.
Mm-hmm.
And I understand Anna Erastus was one of the directors who could not just take any instruction given by the minister, if it is unlawful instruction.
Do you understand, so, or is that what she said in a statement?
It's what I understand. It's what I heard.
Okay. But it's not what she told you.
That's correct.
So this is just what you heard from corridor talks.
It's hearsay, yes.
Yes. So in absence of Ms. Anna Erastus confirming them, you can therefore not verify the correctness thereof.
As I said, we have approached Ms. Anna Erastus with a lot of questions. There are some issues that he didn't want to put in a statement. So we put what she actually responded to the questions that was put to her, but that was not one of.
That was not one of them.
Yes.
Okay. So now we are just drawing conclusions.
Come again?
You are just drawing conclusions since you didn't actively investigate that aspect.
As to why she was recommended.
Why she has to be controlled.
No, that one I did not take it up with her.
Now, after there was a vetting process that was conducted by the Office of the Permanent Secretary, there was then a cabinet submission, a cabinet letter that was prepared by the PS and it was sent through to cabinet. Are you aware thereof?
Yes, I'm aware of that.
And you already testified on that.
That's correct.
Now, you would see from that particular letter, do you have Exhibit XX8?
But before we go to the letter, I just want to say something again on James. Just to say that, as I have testified before, James, his CV and the CV of the PA to the minister were found in the house of the minister. And according to the PA, she said she was approached by the minister herself to become a board member. If they were really to be screened or whatever by the office, then their CVs could be in the office, not at the house of the minister. Why should it be there?
Mr. Kangela, you're not here to ask me questions. You're just here to answer.
I'm answering you like that.
But is there anything wrong if there's a CV at the house of Mr. Esau? Because you also had the CV of Vivian Groenewald.
His statement said he was approached the same way by the minister.
And that was on a recommendation that the minister received.
He never mentioned that it was on anybody's recommendation. He only mentioned that, yes, he was approached by the minister when they were holding an indaba at Danfiliu.
Danfiliu, we will get
Yes.
there. Now, my instructions are that the vetting process was done by the Office of the Permanent Secretary and the cabinet submission was prepared. For the
I don't have
signature-
information as to how the vetting was done, but I know there was something sent to the cabinet, yes.
Okay. And if you go to Exhibit XX8 at page
Yes, now.
at page, are you there?
Which page?
1007.
Yes, I'm there.
That is the 7 May 2014 appointment letter of Mr. James Hatukilipi.
That's correct.
Now, you briefly testified on that letter, you recall?
That's correct.
Now, what you would notice from that letter is that it refers to Clause 15.5 of the State-Owned Enterprises Governance Act.
That's correct.
And that is the section that you testified on never came into effect, you recall?
That's correct.
Now,
And I did also testify that
yes,
there was no any amendment made on the Fishrot Act,
on the Fishrot Act.
which is state-owned enterprise.
Yes, the State-Owned Enterprises Act section, I believe it starts
As
off
I
from-
say, Fishrot was not included. The Fishrot Act was not amended. It was not on the schedule of those acts that were amended.
I hear you, Mr. Kayangela.
Yes.
Can you just allow me to finish my question?
Yes.
Yes. In essence, what Section 15 of the Act provides for is that notwithstanding any other law, that the minister of a designated portfolio, the portfolio minister, may appoint the chairperson of a public enterprise, a state-owned enterprise. That is what the section provides for.
Yeah, but that is for the acts that were amended.
That were amended.
Yes, of which Fishrot was not part, as I'm saying.
I'm not disputing that with you.
Yes.
You must just listen to the question.
I'm listening to the question. That's why I say it only fit for the acts that were amended.
Now, Mr. Esau was advised by his principal advisor, being the permanent secretary, that that section is in effect, and it's on that basis that this appointment was made. He had an advisor.
That is what he have to say, because he know that person could not come back and testify.
But you will not know, Mr. Kayangela. Is it not so?
It is so. That is why he have to shift all the blames.
Did you investigate anything related to the former PS?
There was no need for me to investigate the former PS.
So you did not?
I did not.
Okay. Now, you also referred to that appointment letter was then later shared with some of the other co-accused, or Mr. Johanna Stefansson. You recall that?
Yes, I recall.
Now, my instructions are that Mr. Esau was absolutely not aware what was happening besides the letter being forwarded to Mr. James, what was happening behind the scenes.
The possibility could be there.
Now, one of the issues that was also raised was that Mr. Mike Ikipunya's appointment was not above board. You recall?
Yes, I recall.
Now, my instructions are that it was during the first semester of the year, 2014, that the Office of the Permanent Secretary and the administration organized a briefing session by the outgoing Board of Directors and the Chief Executive Officer of Fishrot, and that session was in essence held at Danville. Do you have any comment there on?
I'm not aware of the session, but what I can comment.
And this briefing session was then attended by officials from the administration, including the management of the Office of the Permanent Secretary, and also members from the ministry itself, which included Mr. Mike Ikipunya, there at Danville.
I don't have that information.
Okay. Now, what then also transpired according to Mr. Esau was that there were eminent vacancies in the board of directors, as well as there was no CEO. And the Office of the Permanent Secretary, together with management, and obviously the Minister's office, was faced with a challenge in filling all these positions within the corporation. Are you aware thereof? That there
I'm
was
not aware of that one.
But there was a need for positions to be filled since the terms came
Yeah,
to an end.
especially for the CEO, yes, there was.
And what Mr. Esau also testified was that his office, in consultation and on advice of the Permanent Secretary and the administration, including the management, identified Mr. Mike Ikipunya as caretaker to be the acting Chief Executive Officer of, I believe it was Seaflower at that time, Fishrot.
Yes, they might have identified him, but what I'm saying is that when he was sent there as a caretaker, as you just mentioned, these people were supposed to get approval from the Public Service Commission. And they never, when they seconded him, there was no such approval. The approval came during June. So they seconded him. James appointed him before any approval from the Public Service Commission office. And that is what was supposed to be now as the Public Service Act.
But the approval did come after 2 months.
It came, but he was already appointed as an acting,
Yes, as an acting.
as from May 2014.
But he was not appointed as the substantive CEO at that point in time. He
That's
was only
correct.
appointed later.
But still, they were supposed to get approval for his secondment.
Now, Mr. Esau was advised by the permanent secretary that they were given the green light by the Public Service
As
Commission.
I say, he have to blame the person because he know the person is no more existing.
But that is the reality, Mr. Kayangela, and that is,
I'm
according to
not-
Mr. Esau, what happened, and you were not there.
That is his defense and that is his testimony.
But you can't dispute it because you
What
were
I'm
not
saying
there.
is that it was not done procedurally as per the Public Service Act.
Now, in terms of the Act, the permanent secretary is responsible for the administration and efficient management of the staff. Is it not so?
That's correct.
And that includes transfers and everything within the
But,
ministry.
but that does not say she must do it against the provisions of the law.
That does not say it.
Yes.
Yes. But Mr. Esau just acted on the person that was responsible for that duty, on that person's advice.
He is a minister. He was the overall head of the ministry. And if we see this thing is wrong, it's not as per the provision, he cannot just authorize it
At that point,
to go ahead.
at that point in time, Mr. Kayangela, how long was the applicant, Mr. Esau, a minister?
How long?
Yes,
He came a minister since 2010.
since 2010. So he was
Yes.
fairly new as a minister.
It's not new.
And the permanent secretary, Ms. Ivelwa, how long has she been?
I don't know as to when she was appointed there.
She was one of the founding ministers, of one of the founding permanent secretaries from 1990 onwards.
But a person cannot be in the position for 3 years and you still regard that person as a new person.
On whose advice does the minister rely in terms of the Public Service Act? Who's his principal advisor?
Is the PS,
The PS.
but she cannot just take everything that is being brought to him, even if she knows that this is not according to the Act.
But there's nothing wrong with Mr. Esau accepting the advice of the permanent secretary.
There's nothing wrong,
Yes.
but what was done wrong is the secondment.
But at the end of the day, within 2 months, there was approval from the Public Service Commission.
You are correct.
Okay. Now, we yesterday went at length and we dealt with the internal memorandum that is under Divider 19. You recall? For the recommendation that was made by the permanent secretary.
Yes, I can recall.
And in terms of that, that internal memo was prepared by the permanent secretary, you recall?
Yes.
And the permanent secretary is the one that would receive the applications for quotas.
That's correct.
And what they then indicated was, here should be the allocation of 42,000 metric tons to non-right holders to be allocated as follows. And then they indicated the National Fishing Corporation, also the Namibia Fish Consumption and Promotion Trust, and 1, 2, 3, Pelagic, Namibia Large Pelagic and Hake Longing Association, and some other two. You recall?
Yes.
So that allocation was then approved by the minister on the recommendation from the permanent secretary and the team that did the evaluation.
That's what I have said. If the allocation is to be made, if the minister did not approve, it means there will be no any allocation. And in terms of the Act, he is the one who will allocate.
And if the recommendation was not made, there would have been no approval of the allocation.
And there will also not be allocation, yes.
But, so there is a process, you would
There's
agree?
a process,
Yes.
I know.
And the minister would then act on a recommendation. In terms of the memo, it says,
The
this is
recommendation,
recommended.
in terms of the memo, but according to, I don't know whether, according to the statement of Maori Hingirire, the minister have to select. But in terms of the bilateral agreement or the memorandum of understanding, I don't think you have to select.
No, for any other applications, Mr. Kayangela, whether it's once it is advertised, there is due process that must be followed.
You
The
are-
minister cannot just directly allocate.
You are correct.
Yes. So what will happen, in fairness and transparency's sake, applications will be brought to the permanent secretary. If an application is not brought, the minister will not know about that application, correct?
That's correct.
And if there is no evaluation done, there will be no recommendation made. That's why they will decide how to do it. Is it not so?
That's correct.
And then they make this recommendation, and the minister then acts on a recommendation, not so?
That's correct.
Thank you. Now, after the minister then approved this recommendation, there were quotas issued or allocated to non-right holders, which prompted then the NEMSOF case in 2014.
That's correct.
Yes. They then lodged an application, I believe it was in September 2014, that culminated in a judgment on the 20th of January 2015,
That's correct.
that those allocations were ultra vires the minister's powers to non-right holders.
That's correct.
Now, what you also testified is that that then led to the amendment of the Marine Resources Act, where the parties came up with a new scheme now.
That is what he indicated in the agenda memorandum that he sent to Cabinet.
Okay.
That it was because of that.
I put it to you that that is not the case. That was not the reason why there was amendments to the act.
Then there was no need for him to ask amendment, and he put that thing in.
For also, even for non-right holders to be awarded quotas. That was not the reason. That is not where it all started.
That was the reason why he asked the amendment, because he wanted to give quotas to the non-right holders.
Now, you do recall there was a recommendation for non-right holders to be awarded, and that was done.
Yes?
Okay. Now, my instructions are that and on the recommendation of the permanent secretary, the Law Reform Development Commission was already brought in during 2012 to work on a targeted report on fisheries. Are you aware thereof?
I am aware of a response letter from Shanghala, but that was 2011,
2011.
when he was asked to reform the Marine Resources Act.
Okay. And then there was engagement with the respective stakeholders.
That's correct.
Okay. Now I want to take you to document. Provide the witness with a copy, Mr. Marangetse. One for the court and one for the witness.
Thank you.
Are you there, Mr. Kayangela?
Yes, I'm there.
Now, this is part of the disclosure additional disclosure that was provided to all accused persons during, I believe it was May, early June. Are you aware thereof?
I'm not aware as to when the disclosure was done, but I know the document.
You know the document.
That's correct.
And while we're on that part of additional disclosure, my instructions are that approximately about further, besides the 95 approximate files, arch-level files disclosure, the accused persons were provided with more or less about 20 more additional arch-level files. Do you have any comment thereon?
That can be possible because I don't know which one was disclosed, but there was like the audit report was having a lot of files. The emails that we get from the office of the district prosecutor in Iceland was also having a lot of files. So it can be possible.
Now, these are the minutes of Treacherous Fishing Pty Ltd. Is that company known as Namsoft?
Yes.
Okay. So these are the names of minutes of 13 November 2012. And if you go to the last page, you would see that the minutes were signed off by the chairperson on 29 January 2013.
That's correct.
Yes. And this meeting was, according to these minutes, held on the 13th of November 2012 in Walfish Bay at the Namsoft Fishing Boardroom on top.
Yes.
And it indicates the members that were present. Kakondi is the chairperson. Fifth row down, there's a Mr. J. Maton, JM. Do you know Mr. J. Maton?
I know the name, but I did not meet him.
Okay. And if you go to page 3 on top, under any other business, are you there?
I'm there.
10.1, Law Reform, Ministry of Fisheries and Marine Resources Fisheries Workshop. It indicates the meeting noted that the Law Reform and Development Commission held a meeting with the industry on issues relating to regulatory reform of the Marine Resources Act, number 27 of 2000. After the industry queries on guidelines, decisions, and basis, the 2012 horse mackerel quotas were allocated on. And it goes on to say that JM, which is referred to as Mr. J. Maton, reported that the Minister of Minister of Fisheries and Marine Resources confessed and claimed that he did not know what guidelines and on what basis quotas was allocated, as this was managed by the Ministry's Planning Division. The Planning Division responded that the main reason behind the allocation was to avoid monopoly and control in the industry, and the Ministry wanted to prevent that an individual or a group association had access to more than 30% of the TAC. The meeting accepted that an individual quota holder may not be allocated more than 1/3 of the TAC, but did not agree with the threshold put on access to quota by the group. As you turn the page, it was proposed that the clause be deleted as the Ministry was mandated to manage the quota and quota allocation and not the economic activity, and that should it be implemented, it would lead to selling of vessels and dismissal of workers. So this is now part of the minutes of Namsoft, and it would appear from these minutes that they were engaged by the Law Reform and Development Commission.
It's just what I have confirmed.
Yes. Now, if there's no objection, Your Lordship, I beg leave to hand up the minutes of Namsoft to be marked as exhibit double Z.
One
Was YY.
Was it not just
Yes.
Y?
Just why?
Was it just Y?
Yes.
We already have a Y, if I'm not mistaken. We are now in the double numbers, so that should be
We are on the double.
double.
numbers.
double Y, and this should be double Z. YY2. We can make the other one YY1, Your Lordship, and this YY2.
Any objections, Mr. Siomunji?
None.
Mr. Marantesi?
None, my lord.
I will accordingly rectify the earlier exhibit marked as Y to be exhibit YY1 and the minutes as exhibit YY2.
Mr. Kayangela, during your investigation, did you come across the Marine Resources Advisory Council and the work that they performed?
I know there were documents with regarding to that were seized from the office of the applicant by the time, but I did not go through them.
Now, my instructions are that the Marine Resources Advisory Council would normally meet, and the permanent secretary was one of the members on that council. Are you aware thereof? The then
I'm not-
permanent secretary.
I'm not aware.
And the permanent secretary would normally brief the minister on the happenings.
I don't have that information, as I said.
You don't have bundle 3 there with you?
Bundle?
No, you don't have bundle 3.
No, I don't have this.
If I may provide you with a copy of this one document, it is Exhibit WW3. My lord, bundle 3 under divider 14.
Yes.
The bundle 14. Do you have the copy of that?
Yes, I do have
Yes.
the copy.
Now, Mr. Esau came to testify on this, that it was in essence a round-robin resolution that was prepared in respect of the Marine Resources Advisory Council meeting that was held on 19 September 2013. And if you turn the page, it was now not signed by all the members. It was only signed by Mr. John Arnold at the last page. Are you there?
Be looking at a different document. Is it, did you say divider 14?
Divider 14, bundle 3.
I think I'm in or WW3.
WW3.
All right. I was on the wrong divider.
Now, this particular J. Arnold, the members there were, if you go to the second page, the chairperson was the permanent secretary. You see that?
Yes.
Yes. And then Ms. Anna Erastus was also a member from the ministry. And then there were other members, 4 members, as well as, if you go to the last page, Mr. Jan Arnold. Mr. Jan Arnold is one of the board members of NEMSOF, the board of directors.
That's correct.
Yes. So the fishing industry was then also duly represented on this advisory council. And if you go to the last paragraph there, and the first page,
The first page. Okay.
yes. You indicated that this is one of the documents that was retained from the office of the applicant on the advisory council.
I said there are a lot of documents that is
Okay.
indicating advisory council, but I don't know whether this one was also part of it.
Okay.
As I say, I did not go through all of them to see what is.
Okay. It reads as follows: Council is discouraging an increase in effort within the mid-water fisheries and right holders competing in the same markets at the same time, which lead to a decrease of price. Council is advising that the whole quota be allocated at the beginning of the season to allow smooth planning in the stretching out of quotas for the year. In terms of allocations made to non-right holders, the Council advises that the Marine Resources Act be amended to cater for this. You see that?
Yes, I see.
So already there, an independent advisory council, which was led by the permanent secretary, the then permanent secretary, advised that there should be an amendment made to cater for right holders.
That's correct.
For non-right holders, sorry.
That's correct. That is what the resolution read.
And as the chairperson, the permanent secretary was the same person that recommended the quota allocation to non-right holders in 2014.
If the resolution is saying that,
Okay. Now, given that the permanent secretary, as part of this council, knew that there should be an amendment, but still recommended that non-right holders should be granted fishing rights to the minister. Do you have any comment on that? In 2014,
they should have granted.
they should amend the act to provide for quota allocations to non-right holders.
Yes, that one is there.
My lord, I don't understand why my learned friend want to read things into documents. This amendment is for mid-water fishery, not just blanket, just non-right orders, specific. Now he just wants to generalize everything else.
Okay. Well noted. Mr. Biegas.
Your Lordship, it actually refers to two different things. They said they're discouraging, it's different context. My learned friend can explore that. The witness testified what this means, Mr. Esau, when he came to testify. I am not just taking it out of context. It was explained that, yes, the first one referred to mid-water fisheries and right holders competing in the same markets, which led to a decrease in that. And then it goes on in terms of allocations made to non-right holders. So there was an amendment to the act that was already proposed for non-right holders to be included. No, that is my learned friend's interpretation. He can canvass it during re-examination,
All right.
as it pleases. Now, what Mr. Esau also came to testify is that this was not a decision that was just sprung up by the judgment coming out, but there was already plans for the act to be amended, for non-right holders to be provided with, or to allow the minister to award quotas to non-right holders. And there was even a inter-ministerial workshop that was held. There was a Marine Resources Legislative Review Committee. Are you aware thereof?
I'm not aware of.
And this Marine Resources Review Committee, they even conducted workshops during early 2015.
I say I don't have those information.
Your Lordship, I believe it is Exhibit H. Should be under Bundle 1. Oh, no, Bundle 2. My apologies. I'm not sure if it's under Exhibit Divider 13, but I have made additional copies for the court's convenience. I removed mine and I couldn't find Bundle 1. Bundle 2, the fish core bundle. But I can provide my learned friend and Your Lordship also with a copy
It's a copy of what?
of Exhibit HH.
I only see my divider 13 is not assigned an exhibit number, and it contains a
A letter.
legislation memorandum to cabinet. That's divider 13, and then there's exhibit LL, which is looks like a similar document. I'll, however, see HH1, but this is a sworn affidavit
Yes, I also only have that H81.
under divider 11. Let's have a look at
Lordship,
the
I do
document.
have
Yes.
additional copies. Your Lordship, the applicant already testified on this particular document,
Okay.
an examination in chief.
All right, you may proceed.
Are you there?
Yes.
Yes, so this is an agenda for the interministerial workshop program for the Marine Resources Legislative Review. And it indicates there that it was held at Vindu Country Club and Resort, the Oryx Conference Center, on the 2nd and 3rd of March 2015. And there the director of proceedings was Mrs. Ilitala Hivelwa, the former PS. And then it outlines what the program looked like in respect of the amendments, or at least for the workshop.
That's correct.
It also indicates there that if you go to the 4th line, there was an introduction by the Marine Resources Legislative Review Committee.
Chairperson, yes.
Yes, by the chairperson. And my instructions on it was also testified by Mr. Esau that there was actually a committee that was established to look into the amendments to the Act. And it wasn't just him that decided that.
I'm not disputing that.
Okay. And that after this committee then sat, and the regulations, they then came up with the draft propositions to this is what we should amend.
I'm not disputing that.
And Mr. Esau was then advised by the permanent secretary and the management team that yes, we can now proceed, and they then also then prepared the cabinet submission for him with the amendments attached to that submission and send it through to a cabinet requesting for the amendment to the Act.
I'm not disputing because I don't know what have transpired there.
Okay. And that is how that cabinet memorandum came up, the one that you testified on the 14th April 2015. It was actually prepared by the Office of the Permanent Secretary. Do you have any comment thereon? As it came from the Legislative Review Committee.
Yeah, my comment is only that he requests for the amendment and he make the case of Namsov as one of the reasons as to why
Yes,
the Act must be amended.
that was also part of the reason. But
Yes.
it has been a process that has been coming.
I'm not disputing the process.
Now then the amendments went through, you testified at length on that. Then there was a further memo to Cabinet that was dated the 4th of November 2015. You recall that one? The one that is seeking permission on the government objectives to Cabinet.
Yes, I can recall.
Is it your testimony that that one was prepared by Mr. Esau?
I cannot recall of having testified that it was him who prepared it.
Because my instructions are that even with all other, as not just with the correspondences, but there is also a correspondence to Cabinet that it would normally be prepared by the Office of the Permanent Secretary and the management.
That can be.
That can be, yes. It is in fact actually confirmed by Dr. Moses in his affidavit, the statement that you referred to. It is marked as Exhibit XX3. And in that particular exhibit, XX3, Dr. Moses refers to that specific cabinet submission having been prepared by the ministry for the signature of the minister.
As I say, I cannot dispute that.
So you see, Mr. Kayengela, it was not uncommon for the correspondences to be prepared through the office of the PS and the management team.
It was not uncommon.
And then Cabinet then identified the government objectives. You already testified on that.
Yes.
Now, after this identification, there must then be an application made to the office of the permanent secretary in order for allocation to be made.
That one, I don't know as to the procedure as from after the approval.
You don't know after the approval.
If the people have to apply or what should be done.
My instructions are that similar process will be followed. They will then have to apply. The office of the permanent secretary would then have to consider. They then have to look at the total allowable catch, and then they would then make the recommendation to the minister, and then so it will go. And then he then approves the allocation. You didn't investigate that part?
No.
Okay. And then once the government objectives, the beneficiaries will then be determined by the Fish Corps management. Once it has been determined it is for trout, the beneficiaries will then be determined by Fish Corps management. Did you investigate that aspect?
Which one is fiscal management? Is it the board or
The
staff?
board and the executive management.
I see.
Yeah, if that is what was to be done, we obtained statement from some board of directors members who indicated that no, the government objective quotas, they will only be dealt with by Fish Corps.
Yes.
And Mr. Mike Mpunya was the only employee of Fish Corps. He was the only one who was dealing with it. They were not involved in the government objective quotas.
The board members.
Yes.
Okay. Because what you would see is, for example, if you go to, you have exhibit XX8. At page 1046.
1046. Yes, I'm there.
There's a letter from the acting permanent secretary, Ms. Anna Erastus, dated 11 November 2015.
That's correct.
And it indicates that the minister, it is addressed to National Fishing Corporation, the general manager, and reference is made to the above subject matter, horse mackerel quota 2015 fishing season. The minister has approved the allocation of horse mackerel quota of 9,000 metric tons through Fish Corps to institutions like Namibia Fish Consumption Promotion Trust, as well as to the Office of the Prime Minister for National Drought Relief for the current fishing season. This allocation is made from the quota which was kept in reserve. So in essence, it refers to the minister has approved an allocation. Again, like the other correspondences you recall.
I can recall, but yeah, this one was specific, and it was for the government objectives that were approved by the cabinet.
Just assist with the page number again.
Page number 1046.
Okay.
There's another one at 1047. But that basically gives us the gist of it. Now, Mr. Kayengela, once these letters are now then sent through to Fish Corps, they then have to decide how to go about. Is it not so? In terms of how they will conclude catch agreements and how they will then make the payments.
Who are those?
The management
Okay.
of Fishrot.
Yes.
As I have said, Fishrot was only beheaded by Mr. Mike Ngipunya. And the board of directors, they are saying, they never discussed, they were never involved in the government objectives quotas. Which means all these quotas, they were being dealt with by Mr. Mike Ngipunya.
I hear you.
Yes.
What I'm saying is then they will then have to decide then what happens, who they will conclude catch agreements with, and how they go about to exploit the quota.
But they could not involve, if they could not decide if they were not involved.
Mr. Mike has a management team.
He's alone.
There was no finance
At
manager.
Fishrot.
There was no finance manager that assisted him
Others, they were employed under Seaflower.
under Seaflower. So
Yes.
Fishrot only had one employee.
According to them, it was only Mike Ngipunya who was with Fishrot.
So the others were not with Fishrot.
The others were employed under Seaflower.
Sorry, I'm a bit lost. So this entity that was established by the National Fishing Corporation Act of 28 of 1991, it only had one employee. The rest were employed by another company.
That is what they said.
No, that is not so.
Okay, even if it is not so, they said they were never involved in the government objectives quotas.
But we will get to that. We will get to a few letters where they've been given instructions what should be done, especially even the finance manager concerning the governmental objectives and how payment should be made.
It's instruction for Mike Ngipunya.
Now, Mr. Esau did not know what happened after that. How the monies were paid and where it was paid and how it was utilized.
But he is aware of how the money was utilized as per the reports of Steer and Fender that he signed.
Now, those confirmations that he signed, they came after the fact,
Yes.
after everything has been done.
Yes, then you must not say that he was not aware as to how the fishing quota was and the payment made thereof, because that one is indicating how much was paid
We will get there. Let's go
and to
to
whom the quotas were allocated.
Let's go to that confirmation. You testified on a particular confirmation letter that was signed off by Mr. Esau. You recall?
Yes.
I believe it was Exhibit XX8, page 1076.
Exhibit
XX8,
7.
Your Lordship.
XX8. The page number again. Have you found the page number?
1076.
76. Yes.
I'm on the page.
You are there. Now, when Mr. Esau came to testify, he firstly indicated that if you look at that particular document, in connection with the 30 September 2016 audit of Fishrot, we noted that Fishrot received hake and horse mackerel quota from your ministry on behalf of third parties as well as for governmental objectives. We understand that there was a verbal agreement between the Honorable Minister and the CEO of Fishrot that should be any balance remaining from the proceeds of the third party quota, the balance should be retained by Fishrot.
Yes, I follow.
So what Mr. Esau came to testify is that what he understands it to mean is that, look, and this is what he confirmed, that there was an agreement with Mr. Mike Ngipunya that once the governmental objective quotas have been paid and it's been paid to the beneficiaries, that remains can be retained by Fishrot.
That is what is indicated in the letter, yes.
what he also came to testify is that he was brought these things after the fact by Mr. Mike Ikipunya. And he acted on trust when he signed off these confirmations. He believed in Mr. Mike that he was doing the right thing, and then he signed off. But he did confirm under oath that, yes, he was negligent. Sorry.
Mr. Biekas, it seems the document says the agreement was between the CEO of Fishrot and the Honorable Minister.
Yes, Mr. Mike.
Yes, but from your question it says if the agreement was between Mr. Mike and someone else, and Mr. Esau only got to know about this afterwards.
No, it was between Mr. Esau and Mr. Mike to retain the monies.
Oh, okay.
Yes. And that when he signed off this thing, he did not want to be a bottleneck. He trusted Mr. Mike, and he just signed it off without doing any due diligence.
Yeah, you have to trust him because he was the one who placed him there, and he's a member of the syndicate.
But you remember that he also, and I put it to you, that that was on the advice of the permanent secretary.
But he did it.
And you also previously testified that if the minister just signs off everything, that would equate to him being negligent.
As a minister, you cannot just sign. You have to check what is the content of the document that you are signing. He was negligent, or he was running the ministry recklessly.
I would agree with you that he was negligent. I normally don't do that, but he also said that yes, he was hoodwinked, he did it blindsidedly, and he signed off these things, and now he's in trouble for that, for being negligent.
He's not just in trouble for negligence, but he have also benefited from this negligence.
Yeah, we will get to those benefits now. Now, you then went on to testify that, look, there were even instructions made for payments to be made to Esau and Nigel's law firm in the amount of 15 million. That instruction came from the minister and James Atukilipi and Mr. Mike. You recall?
I never say so.
Okay. From who did the instruction come?
The instruction of the 15 million, it came from Mr. Mike Ngipunya to the financial manager. I never say it came from the minister.
Okay. Now, Mr. Esau testified that he wasn't even aware of this 15 million that was paid to Mr. Esau Namanje. And he didn't give approval for that.
He might not know.
He might not know.
That's what I say. The instruction came from Mike Ngipunya.
And you also said part of that 15 million, part of it was paid to a certain Mr. Vaino in Kipundoka.
That's correct.
Is he the person from Profile Investments that Mr. Johannes Stefansson said it should also be checked out as part of the syndicate?
I never saw such instruction.
Okay. Then there was a further 2.5 million that was also paid to Mr. Esau Namanje's account. That was also instruction that came from Mike. Are you aware thereof?
I'm aware.
Did you investigate the 2.5 million?
Is that still the trust account, the same account?
That is into the trust account, but it's separate from the 15 million.
All right.
Did you invest what the 2.5 million is for?
Yes, we investigate.
And what did
And
you
Sister Namaja gave a statement. He said it was for the donation to the Swapo party.
So that also includes the 5 million that was then also paid directly by the Samerji group.
That's correct.
Okay, so there was a further 2.5 million and a 5 million.
He said they were all donation for the Swapo party.
Now, on whose instructions?
I know there was an instruction from Mike.
From Mike.
Yes.
But Mike is not charged for that, nor is Mr. Esau charged for those amounts.
I was not drawing up the charges.
You also testified that DHC and SILAX was used as a vehicle and that there was some sort of arrangement that some of the money should be paid directly for the governmental objectives, should be paid directly from the Samerji group of companies into the account of DHC. You recall that?
As I say, it was said it must be paid directly to the beneficiaries.
To the beneficiaries?
Yes.
Okay. And who determined who these beneficiaries was?
That could be Mike.
Could be, or is it?
He was the only one who was dealing with the government objective quotas.
Now, Mr. Maran de Klerk also provided the ACC with a statement, correct?
Yes, he provided.
And that was during early 2020, February.
Cannot recall the date.
But it was early 2020, shortly after the arrest of the accused person.
As I say, I cannot recall the date.
Now, in his statement, he stated that he met with James Atukilipi and Shaki Shangala, who explained that they were mandated by the president, Mr. Haki Geingob, who they referred to us as the boss, to set up a structure to deal with the management and the distribution of contributions paid to the SWAPO party and the government by their supporters. He was also advised that the contributions were expected to increase dramatically ahead of the upcoming elections. And he then further states in his affidavit that he then had to set up some sort of a Hindelemani structure for a trust. You recall that?
I can confirm if you give me a statement, just to check what you are alluding.
I'll provide you with a page. It's at paragraph 112.2 of the affidavit, of the statement. Can confirm.
Okay, that is how the statement reads.
So it appears from the statement that the instruction in essence came from, according to Mr. Maran de Klerk, what he was informed, from the president, who was also referred to as the boss. You just read that now.
Yes, I read it.
And did you investigate this? Did you obtain a statement from the president?
No, I did not.
Why not?
Because of his immune.
His immunity.
Yes.
Does it mean you cannot obtain a statement from him?
In my capacity, I cannot.
You cannot.
Yes.
Now, you see Mr. Kayangela, the former minister, he's now being charged for all those monies that were paid through SILAX. And he's saying that I never gave any instruction to that effect. That went to the SWAPO party in approximately more than 6 million is the report that you went through. And here you have a statement that is shedding the light away from the permanent secretary, and you don't even undertake to investigate that avenue.
Yes, but what I can recall is that there was a video that was going viral where he was requesting money for the SWAPO party. And there was a statement from those who were doing that undercover investigation
Is that the Al Jazeera one?
That's correct.
Is Mr. Esau charged for any of those things?
He's charged with the money maybe that went to the swap party. I'm not sure.
That video that you are referring to, is he charged? In terms of these charges, I'm putting it to you, he's
I
not.
don't know whether he's
Yes.
charged or not.
What you do have here is you have a statement from someone explaining how silax was used, and you just ignore that, and you decide, I'm just going to go after Mr. Esau because of what he apparently said on something he was not even charged for.
I never say I will go after Mr. Esau. We went after him after the decision to charge him was made by the office of the PG.
But it appears that you were selective in your
I was
investigation,
never selective.
but you didn't even follow up on this.
Yes, but that doesn't mean that I was selective.
Now, if this is correct, then it means that Mr. Esau had nothing to do with that, the monies that went through silax.
You can take it as you want to take it.
Now, Mr. Maran de Klerk also in his statement indicate that he only met Mr. Esau once or twice, and that was in respect for him to discuss the setting up of a will and the drafting of a trust for Mr. Esau. Are you aware thereof?
That is his testimony, yes.
And Mr. Esau also in essence testified to that effect.
Yes, I know that there was such because we have those documents that you are just referring to.
And
for
it was
the family trust,
the family trust.
yes, that we get from DHC.
Yes. And that was on the introduction of Mr. Shaki Shangala that took him there, or that directed him there.
I don't know who directed him there.
And when he was there, he then engaged Mr. Maran de Klerk in respect of the purchase of, plot 51, the one that you testified on length.
Yes, I can recall.
And he was interested in this plot, and he signed the necessary documents, and as well that it should be then bought in the form of a CC. You recall?
Yes, I recall.
But what Mr. Esau did not know, and this he testified to, is that, and according to Mr. Maran de Klerk, there was an instruction from Mr. James Hatukilipi to pay the plot on his behalf. Are you aware of that in Mr. Maran de Klerk's statement?
I'm not aware, but I know that there were money came from the law firm for that plot.
I'm telling you, that is what Mr. Maran is saying in his affidavit. He received the instruction from Mr. James Hatukilipi.
James is part.
Now, Mr. Esau did not know. He did not know that this monies for the plot came from silax and that it was in fact even paid on his behalf.
If he could not know, then he could also make a payment. You cannot be interested in a plot. You just apply. You want a plot, but you are not doing any payment to such a plot. Why he did not make a payment is because he knows there are already people who have to pay for that plot. And that is what had happened.
No, that is what your conclusion that you are drawing.
Yes, and that
Yes.
is what he's saying for his defense, that no, he was not aware.
And he did not even know that this property was registered. And that is why he did not even disclose it during his bail application. He just mentioned it and he testified to his erstwhile counsel, Mr. Metcalf, that yes, I was interested in a plot, but that plot was never transferred into his name because he never received the title deed.
But now he knows that the plot was paid by them with the money from DHC. And he never make any attempt to pay that money back. If he was, because he now know that no, my property have been paid with this illegitimate money.
Exactly, Mr. Kayangela. He in fact did take action. When he found out during the initial bail application that yes, there's a plot that was registered in his name, Mr. Esau immediately prepared resolution to say that this property, I don't want it, it is not mine, I want to transfer it back to the state to remedy that wrong.
I just want to keep himself away from it because now he found that no, the people found that yes, this property was bought with that money.
You just testified, Mr. Kayangela. When he found out, this is what he should have done. He should have given back the money.
Yes.
And that is exactly what he did, what you advised now to do.
I never advise.
So you just come up with statements.
I just make a statement.
Yes. But we agree with your statement. That is exactly what he should have done. To give it back, and that is what he did.
If he did that, I'm not aware.
No, it's part of
That
the record.
That he paid the money back.
No, he gave the property back. He said you can take the property. Forfeit to the state.
Don't know whether it is forfeited or he just say
We
the
don't
state
know.
can take.
Yeah, no, the state can take it. He filed the necessary documentation.
Okay.
Because he ended up in court. Now, Mr. Kayangela, we are almost done. My instructions are that Mr. Esau, he just acted on good faith and on trust and on recommendations that were made to him, and that if there was a scheme, that he was most certainly then used.
I'm not agreeing with his statement.
Your Lordship, may I just take a brief instruction if there's
Yes.
anything else? Your Lordship, that is a cross-examination. I have no further question for the witness. As it pleases the court.
My lord,
Yes.
we have to. I made copies as it was instructed yesterday
Of all those documents.
for these documents.
See,
It's something that I don't watch the state properties.
yes.
It says I think it's 3 or 4 sets. No, it's 3 sets.
Yes.
One set is for the business profile of Samiri. It was referred to. There was a business profile that was referred in a statement, in an email that he requested me he must provide. So there were 3 that were found at the applicant's house. 3 business profiles. And there was another document a sea frozen operation in Namibian waters, Katla Seafood. This document is very important to my testimony. And it is having few emails where it was discussed, which I want to read in the record. The business profile I'm having is for, one is for August 2012. The other one is for 2011. And the other one is for 2014. I have made enough copies just to share them, just to prove that yes, indeed, there were some business profile found with the accused persons in the accused person's house. This one is for the 2012. This one is for 2011. It's 3 copies. One for him and one for the state and one for my lord, perhaps. And this one is for the 2014. Then the last set is for the sea frozen operation in Namibia. And the last set is for the emails. And these are the emails that I want to read through with regarding to this sea frozen operation in waters Katla Seafood. Okay, these emails, they were translated by one of the investigators from the office of the district prosecutor in Iceland. They are marked from page 1, 2, 3, 4, 5. Okay, on page 1, there is an email with the name of Johannes Stephenson on top. And this email was from Johannes Stephenson, dated Monday, December 12, 2011, to Adelstein Helgason, CC Ingval Julison, Sameri, with the subject Sea Frozen Operation, Namibia. Attachment set up Sea Frozen Operation, Namibia. The content reads, greetings Adelstein. See attached Sea Frozen Operation that the minister's daughter and son-in-law will take to him this evening. Would you box this and send us comments? We need comments soon, and we'll print it out on quality paper and bind it. Thanks, best regards. The second page is another email to Adelstein Helgason, copied to Ingval Julison Sameri, with the subject emailing set up Sea Frozen Operation Namibia, and it reads as follows. Greetings, splendid. We will have it printed. Then they are to be delivered the project somewhere where no one will see us. They are both regards, Johannes. Then,
Which page what?
page 2, in the circle.
Okay.
I'll go to page 3. It's also an email from Johannes Stephenson, dated December 12, 2011, to Adelstein Helgason, saying Namibia situation. Greetings, Adelstein. A few points, and I'm only going to read point 1 and its content. The son-in-law got the Sea Frozen project area and took it to the minister. We also gave them the letter with the job creation for the land processing of horse mackerel. Then letter A, he then returned a few hours later after going to the minister's home. The minister is in South Africa, but will return on Thursday and will proceed straight to his ranch. Let us see the family, minister's wife, minister, daughter, and son-in-law. discussed the matter by telephone, and the minister's wife is to take the project to the ranch to show him the project. Little D, it was emphasized that they would be taken care of, and we will meet the son-in-law again, possibly on Wednesday, with a possible draft of an offer. The lawyer will arrive tomorrow. There are a lot of things that they may mean with this, but it does not mean using the son-in-law or cheating, but make something good of this and employment for the son-in-law and income, etc. We will then see what comes out of it, but this is one of the roads we are taking. Okay, this came from Johannes. Then I go to page number 4. It's also an email from Johannes, dated December 14, 2011, to Adalstein Hergason, copy to Ingval Juliusson, Sameri, subject Namibia situation. Then it reads, we met 2 Hague quota holders this morning. One new and also his partner Shimi came again. And we will take the matter forward. But we will do that with the lawyer. We are trying to come up with a proposal to take the matter forward. Our lawyer is expected tonight, and the target is to complete the agreement and MOU as soon as possible, preferably tomorrow. When we have approved it, the idea is to start getting groups to sign, preferably before and on the weekend. It might be that we are becoming pressed for time, but we will see what the situation is in that regard. Possible an MOU will be signed to begin with, but we will see what happens when the lawyer arrives. The son-in-law will then follow up on the rest. That is to say, the sea freeze project that was created for him and the minister. The minister will look at it over the weekend at the ranch. Best regards, Johannes. My Lord, that is just a showing to say that indeed the minister was being briefed, and the project alleged in the emails, this document was found at his house. It was among the documents found at his house when the search was conducted, which means he received it. That is all, my Lord.
Certainly, let me hear your stance on this.
Your Lordship, may we just have a short comfort break, then I will quickly canvass it before I close my cross, because it's something that I have to address now.
Okay. Mr. Siomenju, would you like to say something?
My Lord, just to state that I was left out in the distribution of these documents.
Oh, the one that is reading.
Indeed so, my Lord.
Okay.
But please the court.
Mr. Marondese, will you take care of that?
Thank you, my Lord. Yeah. I'll talk to Mr. Simon.
Counsel, you will have me called once you are ready to proceed. But we should proceed just in a few minutes as soon as you
Just
are
10
ready.
minutes, Your Lordship.
Yes.
As you please the court.
Ulajo. Mr. Biekas?
Yes, please, the court. Lordship, I just have a few questions to the witness.
Yes.
Mr. Kayengela, these emails that you referred to, these emails were not found at the residence of the applicant.
That's correct.
Okay. These emails, I'm not sure if you do know, but the authenticity of these emails have already been challenged in the bail application of Mr. Thames and Atikilipi, and we continue to challenge them.
Yeah, well, this was attached to a statement of the person who extracted them.
Just repeat that.
These ones, they are attached to a statement given by the investigator who submitted of the district,
Okay.
from the office of the district prosecutor.
All right.
In these statements, this email, it looks like it has been typed over. If you print an email, does it normally indicate there on top document ID 07487.87033?
How it was printed, I cannot explain. As I said, it is a translated document.
It also at the bottom indicates custodian, Joanna Stefansson.
Yes.
It's also typed over the email.
I don't know how it was put up.
No, I'm putting it to you. On the face of it, it's been typed over the email.
I cannot explain that. That's why I say it is an understatement
And if something
of
is
the
typed,
person who provided it. And he also the only one who know how he did it or how she did it.
Okay. And your earlier testimony during examination in chief, or I believe it was during cross, you said that these documents were found on the farm, initially on the farm of the applicant, the profile,
Which profile?
the company profile of Samerji,
I never mentioned of any document found on the farm. I
So-
talk of documents found at the house.
found at the house.
Yes.
Okay.
And I said they are attached to the statement of Olivier,
Of Olafir.
who conducted the search.
Now, these documents, or at least the emails, let's first deal with the documents. These documents don't discuss anything about the scheme, the Nemgoma scheme.
There was a request
Listen to the question.
to said, and I will explain why I submitted them. There was a request. There was an email that is saying, the minister might be asked, who is Sameri? Then they say, a profile must be submitted. That's why I brought these profiles.
Is it
Just to know that, yes, indeed, there were profiles of Sameri found at the house of the applicant.
Mr. Kayengela, that email actually said, the president may ask who is Samherji, not the minister. You recall that?
Okay, yes.
And that one also referred to a 2-page email, not thick documents. They said, can you please send a 2-pager through?
But that is what was found at his house.
Now, Mr. Esau also came to testify. Before we go there, in terms of this email that you now went through, it would appear that the documents, at least from here, they were given to Mr. Esau's wife, who then took it to him on the farm, from the email that you went through now.
Yes.
Now, I took instructions now from Mr. Esau's wife, and she said she was never provided with any of these documents to give to Mr. Esau.
But it ended up in his house.
And not on the farm, because the emails are saying it would have been taken to the farm.
You can go with to the farm. It can be given to you at the farm. You can come with it to your house.
And this document only refers to one document, not all the profiles.
Yes, to one document.
And during 2011, when Samerji came to Namibia, are you aware that they tried by all means to get the attention of the minister?
Yes.
And they've sent through their profiles and documentation through his office. Are you aware thereof?
I'm not aware, but I know that that was an email that is asking for the profile to be given. If he was already having it, then there was no need for such email.
That is what Mr. Shankala said. Can you please give us, and that was in 2013, on the profile,
Yes?
a 2-pager to brief the President of the Republic of Namibia.
Yes?
Now what then also, from these documents, this sea frozen operations in Namibia waters, Cutlass Seafood. It never transpired.
I don't know whether it transpired or not.
I'm telling you, it never did.
Which one is that?
The first document of 2011 to stroke 2013.
Whether it is not, it don't materialize or whatever. What is confirming is that there was indeed a flow from Sameri to the applicant, just as per the email.
Now, all that those emails say is that documents were given to Mr. Esau's wife to take to Mr. Esau. That is what it's saying.
The emails is talking of the sea frozen operation.
Yes.
Yes.
It's just a sea frozen operation. No discussions on any entry into the market, no discussion of any Nemgomar scheme. All that it's saying is just a sea frozen thing. And this thing, according to Mr. Esau, it wasn't even brought by his wife.
I don't know who brought it, but it ended up in his house.
In fact, some Herjee group of companies were so desperate that they even sent the late Harold Pupkowitz to the office of the applicant.
I don't know.
You won't know.
Yes.
And he also brought these documents to them. First one, and which one is it? Another profile, earlier profile, 2011, 2012 profile, that was brought to Mr. Esau.
That I don't know. I don't know whether they also took it to Pukevis.
And then what also happened is they kept on sending their profiles through there to a point, and Mr. Esau testified that they were brought in a closed bag to his house by the driver. That is how persistent they were.
I don't know.
And just listen to this. What Tamsin is saying, not Tamsin, Johannes is saying that he was told by Tamsin that Tamsin was told by the wife that this is what happened. And this never happened. You can't dispute that.
That is in the email of Johannes Stephenson. So I
The
was not there.
self-confessed criminal.
I was not there when they were discussing.
You were not there, so you
But
cannot
that is
say.
but that is what he's saying in the emails.
And even in this email, it does not indicate that there were discussion of the Nemgomar scheme. Is it not so?
Yes.
Yes. But now you want to draw a conclusion from this one. The email that we are, the authenticity that we are challenging, you are drawing a conclusion to say that, oh yes, now he was briefed. Because what he is saying, Mr. Johannes Stephenson, is that the briefing came from James and Saki. Those were the ones that would normally brief.
If the documents have to be submitted to a person, you cannot just submit. At least you have to say as to what is the document all about.
But you did not obtain a statement from Johannes explaining any of these affidavits, confirming these emails, confirming any of these emails.
Yes.
So up to now, Johannes can't even confirm that, yes, I sent these emails, and your investigation is complete.
Johannes, he gave a statement regarding the emails that was extracted from his computer or from wherever. He gave a statement. He can testify on the emails.
Did he give a statement to say, this is what happened, this is the email that I sent, this is how Mr. Esau was engaged? Did he do
They
that?
are attached to the statement. He can explain them because they are attached.
But he have not explained them. Is it not so?
Not in the statement.
And you are now just drawing conclusions from
I'm
them,
not
not
drawing
so?
conclusion.
They are attached to whose statement?
To Johannes Stephenson's statement
You mean these emails?
that he gave when he was approached by the investigators of the Icelandic.
So there's another statement
Yes,
from Johannes Stephenson.
yes.
And it's earlier testified that these emails were provided by someone from the district prosecutor's office.
I indicate these are translated email. There were people who were investigating in Iceland. They went to Johannes Stephenson. Johannes Stephenson gave them a statement. On the statement, he attached the emails. There were other emails. If you see, those were written confidential. Those were directly from the office before the statements were given.
Earlier testimony and some of the documents that were filed, these emails were also filed in the POCA application, do you recall? As part of the affidavit that was exchanged.
I
between
cannot recall.
The Prosecutor General's office and the defendants in that matter.
No, I cannot recall.
And the explanation that was provided there, that these emails does not come from Johannes. They were printed from the server apparently, and that someone gave an affidavit there too. Not Mr. Joanna Stephenson.
Okay, the person who gave an affidavit will come and explain.
So what I'm putting to you is, it's not the correct version to come and say that, yes, Mr. Joanna Stephenson provided an affidavit attaching all these emails that were taken from the server. It's not so, because we don't even have that affidavit.
But there is an affidavit.
But not from Joanna Stephenson, is it not so?
I said there is an affidavit from Johannes Stephenson that is filed on the case file.
My learned friend can just go in. Unfortunately, he does not have the latest disclosure that was given to his client because it's pulled out of the main case. Those emails were disclosed to the defense with that affidavit of Stephenson.
Okay.
And if there's an affidavit, Mr. Stephenson does not explain these emails.
That's why I say they are in attachments. He can explain them anytime if you want to approach him and for him to explain.
Unfortunately, we don't have an opportunity now. It's just bail.
Okay.
I have no further questions, Your Lordship.
Thank
Would
you,
please
Mr.
the court-
Bierkas. Okay. Any suggestion on the way forward, Mr. Siomunji?
My Lord, I'm ready to start.
That's in order. Mr. Bierkas? Mr. Bierkas, your colleague needs
Oh,
assistance.
sorry.
My lord, if I can just hand over the seat to
Oh, I see.
Mr. Pingi.
Yes, that's in order. Oh.
That's fine.
Just to remind the parties that these documents that were presented by Mr. Kanyangela were not marked as exhibits, but they were read into a record and you cross-examined on them. I'm just going to assign for my own identification. I don't know if you want to suggest something, Mr. Barondesi.
My lord, I thought Mr. Bierkas was going to suggest that they demand this.
All right.
I will still suggest that they mark as where I come from, the call is Z, but here the call it Z.
Okay. ZZ.
ZZ.
Okay. Is that in order? Thank you. Mr. Siomunji, you may proceed.
May it please you, my lord. Mr. Kanyangela, just to start off with, if we can just get some rules of engagement, of course through the court. I'll ask you a question, please answer my question. Of course, even for the interest of the court wants to know if you know the answer to that question. I wouldn't expect you to speculate. And you are also entitled, if you don't want to answer my question, you are entitled. You can just simply say, I will not answer your question, and I'll move on. Now, having said that, sure you are well aware that I'm representing the second applicant.
I'm well aware.
Okay. And you will agree with me that his facing several charges, which among them are racketeering, money laundering, obstruction, theft, just to summarize.
Yes, I'm aware.
Okay. Now, let's start off with, I'm sure you are provided with the new facts. I'm sure you should have been provided with the new facts by Mr. Ipinge.
I don't know whether I've been provided with them.
Well, you should have been, because we placed that on record. I'm just saying, of course, what you and him discuss is privileged, but you should have.
Yes.
That's why I said you should have, because
Yes.
we placed that on record. Now, let's start off with this Leonardville case, the one of 27 November 2019, where the allegations are that he obstructed ACC and police officers from executing the arrests of Mr. Shangala and Mr. Hatukilipi. I'm sure you agree with me, as you've stated on record, you were not there, isn't it?
Yes, I was not there.
So you were just provided with secondary information.
From the statements that had been given, yes.
Okay. Now, applicant informed the court that on the said date, in fact, the day before, he was informed by Mr. Hatukulipi and Mr. Shangala that they will be going the next day very early in the morning to go and vote.
I did not come across such information.
Of course you will not, unless you were in court or you were provided with a transcript. I'm talking about the testimony of Mr. Van Wyk.
My Lord, there was no such testimony on record. The only thing that Mr. Van Wyk testified was there was a fortuner, there were comrades of Saki, and those comrades will be leaving early in the morning. There was nothing about voting.
There was nothing about?
Voting by Saki and James, by the testimony that was led in this court.
Okay, but I recall testimony of someone leaving early in the morning.
The comrades who were in the fortuner.
Okay,
Yes, that's it. Not that Saki and James are going to, the comrades are leaving.
all right.
My Lord, there was such testimony about voting, and it was early in the morning, unless my learned colleague missed it.
Okay.
So the crux of the issue that I'm presenting to you about Mr. Van Wyk's testimony is that because he was told that they were leaving early in the morning to go and vote, when the ACC officers asked him whether Mr. Shangala and Mr. Hatukulipe were present at the farm, that is in the home, when he informed them that they were not present, it's because he believed that they were not there because they told him they will be leaving early in the morning.
As I have said, there's no such information to say that they are going to vote. And according to the statement of those who went there to execute the warrant of arrest, they were informed. He told them that they left in the morning.
Exactly. And that's
Yes.
what I'm saying.
He
It's-
did not say. I'm thinking they have left in the morning. He said they left in the morning. It seems he saw them.
Mr. Kanyangela, if you have a meeting with your Director General today, and he tells you, Mr. Kanyangela, tomorrow, Friday, 1st September, early in the morning, I'll be leaving, going to X place.
Yes.
And somebody asks you about the whereabouts of your Director General early that morning, wouldn't you say that he has gone to X place?
I will not say.
What would you say? Would you say you don't know where he is?
I will say, I know he was saying he is going for a meeting.
Yes, on that day,
But
isn't
I
it?
cannot say he left
Yes, that's
because
what
I
you
did not saw him leaving.
Exactly, but the point is, Mr. Van Wyk indicated to this court, when he said that the two, that is Mr. Hatukulipe and Mr. Shangala, were not there, it's because he believed that they left as what was indicated to him, what was told to him.
But when his answer was like he saw them leaving the farm,
Are you saying that's what he said?
I say, when he answered, Their statement is saying, he said they left here in the morning,
And he saw them leaving,
as if he saw them.
as if.
Yes.
Did that person who wrote that statement, did he say, he asked him further, did you see them leaving? And he said yes.
No.
Exactly. So that's that person's understanding or interpretation. So that cannot be imputed on Mr. Van Wyk. You agree with me?
I can agree with you.
Yes. So moving on now further. It was that version, in fact, was not disputed in cross-examination. If I can just put it to you.
Okay.
It was not disputed. And now moving further, the issue of that there was this obstruction that Mr. Van Wyk allegedly prevented the ACC officers from entering the house. That is the obstruction charges and the assault charges. That is Mr. Klute, Mr. Seron, and Mr. Olivier.
Yes.
He explained it. He said that there was no obstruction. There was no scuffle. In fact, what he even explained further is that if you look at even the stature of Mr. Klute, I'm sure you agree with me, he's not a man of small stature, isn't it?
That's correct?
Yes, he's huge.
That's correct.
Yes. Mr. Seron, Chief Inspector Jackie Seron, sure you agree with me that he's also not a man of small stature.
Yes.
Yes. Then there was Mr. Olivier.
Yes.
So the three of them, how would, if you look at the stature of Mr. Nigel Van Wyk,
That's why they overpowered him.
they overpowered him.
Yes. He was trying. And if they overpowered him,
So when they overpowered him, what else did they do?
they arrested him.
They overpowered him until the ground and arrested him.
Yes.
Did they handcuff him right there?
I don't know what. I know he was handcuffed. The statement is what he's saying.
I'm asking you, sir, because you are the one who is in charge of the investigations. You are the one who is presenting that narrative.
Yes, and I present it as it is mentioned in the
Okay.
statement. Because I have already indicated to you that I was not at the scene.
Are you aware that there's statements from Mr. James Hatikulipi and Mr. Saki Shangala concerning that same incident? They gave sworn affidavits and they deny, particularly Mr. James Hatikulipi, who is the first one who came, he denies that there was any such incident, there was any such scuffle between the said three officers and Mr. Van Wyk.
Yeah, they were defending their co-accused.
If that was the case, that was not challenged in cross-examination. It was not put to Mr. Van Wyk that they wrestled, those three officers wrestled him, put him on the ground because he was trying to resist or trying to obstruct them from entering the house. That was never put to him.
I was not in court.
But I'm telling you what is on record, because
Okay.
obviously you are not in court because that was not your part
Okay.
to come in.
Yes.
But you were represented. Moving on, you indicated a very interesting version that Mr. Van Wyk, again, that is to do with the Leonardville case, indicated that to the officers, that is, the three officers, Mr. Klute, Mr. Van Wyk, and Mr. Seron, that they will not enter the house, and that will be over his, I think, over his dead body, something to that effect.
That is what in their statements.
Okay? That is interesting. You know why I'm saying it's interesting? That version was not put by your lawyer to Mr. Van Wyk in cross-examination, that he actually obstructed the three officers. He even said that they will not enter that premises over his dead body.
I don't know why he did not.
That's